capacity. So this is the fourth and last session of this series, of this bid protest series. We ran a similar series last summer on federal bid protests, and this one is on state bid protests. This series has been a very successful opportunity first to introduce how state bid protests work. In the second session we talked about some of the issues that commonly arise and how they can be avoided, some of the common issues in state bid protests. We had a very interesting session on Tuesday, then the third session on improving the bid protest process. And that ties into an ongoing effort to reform the Model Procurement Code. The Model Procurement Code was published by the ABA in 1978, and it was republished by the ABA in 2000. It serves as a template for 17 states around the country, and many, many local governments rely on it as well. It's also been picked up by other governments. Elements of the Model Procurement Code have been picked up. And the Model Procurement Code is being reformed now. That process is unfolding right now in the Public Contract Law section of the ABA with the National Association of State Procuring Officials and the procurement officials, and also with the National Institute of Government Procurement, NIGP. So there are major efforts underway right now to reform the Model Procurement Code. And our session this evening, the mock bid protest session, is an important part and analysis of some of the areas of possible reform in the Model Procurement Code. For members of our audience who are interested in this topic, please feel free to let us know that you would like to be involved in the Model Procurement Code reform. That reform effort is likely to take several years. It'll be a complex and thoroughgoing reform of the MPC. So the session we had earlier this week, the third session we talked about, was a session where we really reviewed in detail some of the issues that are rising in particular states in California and Nebraska in the bid protest system. And we were joined by Mike Carnahan, who's one of the newest members of the Maryland State Board of Contract Appeals. And he talked about how since the 1970s, the Maryland board has really grown into really an exemplary board. It was from a lawyer's perspective, it was almost funny because lawyers from other states were saying how jealous they were of the Maryland board. And it was nice. It was very nice for Mike to express in very clear terms what the goals are, the principles that drive the board's work. Principles of transparency, of trying to make the system better, really trying to be fair to businesses in order to encourage them to compete effectively in Maryland procurement. It was really something. I was really very proud that we were able to hold that session. Now, the recording from Tuesday, like the earlier recordings, is available on the Public Procurement International website. That's my blog. It's also available on the web, on the YouTube page for the GW Law Government Procurement Law Program. So if you go to YouTube and you search for GW Law Government Procurement, you'll come to our page and you'll see the recording there. So this evening we're going to be joined by a panel of judges, and the idea is that you're going to be able to receive different perspectives. This is going to be a hot bench. So while Larry Kreis is going to be leading, he's going to be the lead judge, we have other judges who will also be asking questions, so you'll hear their different perspectives. Judge Kreis he has a JD degree from the University of Maryland, as an undergraduate degree is from Towson. He has been a board member since 2019. He's also an associate judge in the state system, in a circuit court judge in Maryland. So he has a lot of practical experience as a trial judge. He was previously in the Attorney General's office in Maryland. Those of you who participated in earlier sessions, we've had Lydia Hoover in several sessions, and she is currently in the AG's office in Maryland. We also have Justin Kaufman, who is the Chief Legal Officer for NASPO. He and I have worked together for many years. He was previously a procuring official in Minnesota, and he and I first started working together at that point. He's traveled and published with me internationally, working on procurement issues, and he is very much leading the charge as NASPO helps to push forward reform in state procurement. We're at GW, we participate with NASPO in many different programs because our students get a lot out of working with NASPO, and we really enjoy working with NASPO. It's a very, very professional organization, and they're doing a great job in pushing forward procurement reform across the United States. We're also joined by Sarah Hildebrand, who is with NASPO. She's the Chief Operations Officer at NASPO. She was the former Chief Procurement Officer in Idaho. We have Mike Beavis, who is the Chief Procurement Officer in the city of Norfolk, Virginia. He has a law degree from Georgetown Law and a bachelor's degree from Lincoln Memorial. And so Mike is going to be one of the reporters on the effort to reform the Model Procurement Code. And Mike obviously has a strong legal background, but he also has the background of someone who's working in local procurement. We have with us as well Bryce Fisk. He's legal counsel with NASPO, and he has a law degree from William & Mary Law School. He actually served in the state AG's office in Richmond with Andrea Adibe, who's also going to be judged. Andrea is now working at the U.S. Department of Homeland Security, and she was previously, as I said, an assistant AG in Virginia. She has an LLM degree from GW. She's a former student of ours, and she was a delightful part of our program. She has a JD degree from the University of Florida and a master's, also Master's of International Business from the University of Florida, and she has a bachelor's degree from Jacksonville University. We also have with us Faye Tan, who's a legal counsel at NASPO. She was the former assistant director of purchasing in Idaho, and she has a JD degree from the University of Utah. And I think that covers all our judges. So what I want to do is, by the way, if you're interested in reading the problem that we're going to be using this evening, it's available in Public Procurement International. If you just go to the program page, which is available right there on the top of Public Procurement International, you can drill down to this problem that we'll be using. So I'm going to ask the presenters this evening to introduce themselves. I've introduced myself. So but when we start from the top with the protester, Joseph and Jacob, if you could introduce yourselves.
I am Joseph Dobert. I am a buyer with the city of Minneapolis up here in Minneapolis, Minnesota.
Hi, everybody. My name is Jacob Green. I'm a rising 2L at George Washington Law. And this summer, I've been an intern with the New Jersey Office of the Attorney General.
Hello, good evening. This is Sarish Rawat. I'm a former student of the GW Law Government Procurement Program and currently a government contracts attorney.
Joseph, you want to say hi?
Sure. I'm Joseph Singer. I'm a self-employed business analyst, management consultant, a certified management accountant, and I've dealt with mostly city revenues to the economic development plan that they place together, mostly with real estate and some corporations. I sometimes sit with the International Economic Development Council on some of the programs and requirements. That's about it for me for now.
Nice. Keith, you want to say hi?
Yeah, my name is Keith Montoya. I'm with Arizona State Parks here in, Senior Procurement Specialist with Arizona State Parks.
Thanks a lot, Keith. And as I said before, I'm Chris Eukins, and I've stepped in because we lost one of our participants. So those of you who are new, those of you who are watching who are new to the protest process, this is a classic structure of the presentation. The protester is going to go first and be able to present the grounds for the protest, and then the agency will respond. And then the intervener, who's the awardee under the facts of the case, and again, the facts of the case are available on the program page. The intervener is the awardee, and you can see that if the agency is trying to rebut the protester, the intervener is the awardee. Also, the intervener's interest is aligned with that of the agency. It's a complicated relationship between the awardee and the agency, because if the agency decides to take corrective action, the agency may say, oh, we're going to do the competition over again, and that leaves the awardee out in the cold. So while technically the agency and the intervener are aligned with each other, and they might be cooperating during the litigation behind an attorney work product privilege, in reality, both parties have to be very careful with each other. Because it could turn out that suddenly the awardee loses the contract, because the agency decides to take corrective action. So this is a typical three-party setup for protests. It's good to understand that this is a normal alignment of the parties in a protest like this. So with that, I'm going to turn it over to you, Judge Kreis, and I'll have you go ahead and have the agency walk through. Excuse me, I apologize. We don't have a slide from the protester. Judge, if I could turn it over to you, and if you could have the protesters present first.
Great. Good evening, everybody. We have a panel of judges that are going to hear this today. We're going to hear from the protesters first. The protesters have been allotted 24 minutes to go through their presentation. That's based on basically 3 minutes for each of the 8 issues they want you to address. We're not going to divide it by individual issues. We're going to give you the 24 minutes and maybe a little bit more with questions. Then after the protester, the agency is going to go, then the intervener. We're here both today on the protest of West Carolina medical equipment, as well as the motion to intervene of World Equipment. We're going to have World Equipment deal with its motion to intervene when it gets to its argument after both the protester and agency have gone. Unless anyone has any questions before we get started, anyone has any questions before we get started? Okay. Then I will turn it over to the protesters to present their case.
Thank you, Your Honor. May it please the board, my name is Joseph Dobert. I'm here with Jacob Green, presenting on behalf of West Carolina Health, the aggrieved bidder in this action. Tonight we're going to demonstrate some serious defects in the current bid. We're going to ask the board to take corrective action. To do this, we're going to first demonstrate the board's authority to hear the matter. We'll demonstrate West Carolina Health standing to bring this protest to the board and the timeliness of that protest. We're also going to show that World Equipment has no standing to intervene in this matter. We'll respectfully request that their motion to intervene be denied and that they not be heard this evening. With respect to the bid itself, we intend to expose both agency conflict of interest involving World Equipment and to demonstrate egregious misrepresentations by World Equipment to the state that have made it impossible for the bidding event to be fair or impartial, and we'll ask the board to take action to remedy this situation. Thank you.
And who's going to be arguing? That was a nice introduction. Who's going to be arguing next for the protester?
Jake is going to jump in right now, Your Honor.
Okay.
I am, Your Honor. I thought the other teams might introduce themselves as well, but Jacob Green here representing the protester, and Your Honors, I'm here to talk about the board's jurisdiction. Section 9-505 of the West Carolina Procurement Code states the board's jurisdiction very clearly. Unless certain circumstances have been met, this board will have jurisdiction to hear our bid protest today. Those conditions include whether or not we filed a lawsuit in a local court, we have not, or whether or not various entities have objected to this board having jurisdiction in the current matter. The Attorney General, various other bidders, none of those entities have met that requirement of supplying a written objection to this board's jurisdiction. So in this case, simply put, this board does have jurisdiction to hear the bid protest today.
Thank you.
We also like to establish West Carolina Health standing to bring the protest to the board. Both standing and timeliness are clearly spelled out in the ABA Model Procurement Code. Section 9-101, paragraph 1 says, any actual or prospective bidder, offerer, or contractor who is aggrieved in connection with the solicitation or award of a contract may protest. West Carolina Health is both the prospective bidder on the contract and the current contractor for the year that's ending. So they are therefore eligible to submit a protest. Now, the same paragraph of the procurement code goes on to say, the protest shall be submitted in writing within 14 days after such aggrieved person knows or should have known of the facts giving rise thereto. This protest was filed 2 days after West Carolina Health was made aware of this conflict with the release of some damning email between the state and World Equipment. So therefore, we do have standing and our timeliness requirements have been met.
But counsel, wasn't the information that you ultimately received available publicly to anyone looking for it 4 weeks before you filed the protest?
The information was posted by a whistleblower to the website. However, we had no knowledge of this, no way to know that it was out there. It wasn't until 2 days before we filed the protest that we were actually made aware of that. And the code is made aware of this conflict. So I believe that we've met that by filing it literally within 2 days of that instead of 14.
So
But I do agree that it was, I'm sorry, I didn't mean to interrupt, but I do agree that it was out there for several weeks before that. We were just not made aware of it.
But so your position is you didn't have any obligation to do your own due diligence to find out this information?
I wouldn't say that we didn't have obligation to do due diligence to find this information. We of course always have to be on the lookout for that, but there was no indication that there was this kind of collusion going on between the state and World Equipment until PGP filed their Freedom of Information Act request and posted the documents on a whistleblower website. We had no way to know this. This has not been a concern with the state in the past. So it caught us off guard.
Okay, thank you.
Thank you.
I have a question, a quick question. When you say made aware, how exactly were you made aware?
One of our staff stumbled upon it while they were actually doing research into this. So we did go out looking for it, and it's not that we didn't do any due diligence. We just weren't able to catch it within 14 days of it being posted. So let me look at my notes. Were 4 weeks, just an employee of WCME found the email chain on the PGP website. So it was just by going to their website that we happened upon it. So PGP didn't notify us. We didn't know that there had been a Freedom of Information Request Act to this point. It's just purely accidental, and that's why we moved to get it filed within 2 days of that date.
At any point, did West Carolina Medical Equipment submit a direct request for documentation to West Carolina Hospital?
We had not, no.
Would you like to continue with your argument?
I'm gonna turn it over to Jake to talk.
Yeah,
to
if
talk
we
about
can,
WB.
if we can separate our standing and our timeliness arguments. A few other points on the statute in terms of known or should have known. Actual notice in this case is very clear. Within 2 days, we turned around our bid protest. And in terms of a constructive notice, should we have known about these emails? We are thankful to the civil society group who did file those record requests, but we don't believe that it is our duty necessarily to file a record request with every single bidder, with every single employee who's involved in every single protest. We think that's an overwhelming burden. We are doing our due diligence to make sure we are constructively aware of the situation. We're doing our research to find that information. And once we do have it and possess it, we filed a timely bid protest that we can tell. Now, moving on to the standing of the intervener in this case, we're looking at similar statutory language from the procurement code, and we believe that World Equipment has not met that requirement to be allowed to intervene in this case because they are not an aggrieved party. They have not suffered any kind of harm to date. Meanwhile, they have actually gotten ahead based on their anti-competitive practices.
So your position is you want to either exclude them or have something that prevents them from participating in the procurement, but you don't think that gives them standing to participate in the protest that's trying to exclude them? Is that your position?
Our position is that their interests are best represented by the agency in this case, and that they are not an aggrieved party as 9505 lays out to become involved in the protest itself. As of this moment, yes, they are still allowed to be involved in the procurement process. We're going to argue that because of their actions, they should be excluded as well. But purely on standing to join the to intervene and join the bid protest, we believe they're not an aggrieved party that would match that requirement.
Does World Equipment not have a property interest in the award?
They, in theory, they have a potential property interest in the award, and as we see at this moment, that interest has not been aggrieved, and the agency in this matter is in the best position to represent that interest. So it's not like they've been excluded from the process either. They still have representation here.
So is your argument that the agency, West Carolina Hospital, should be defending World Equipment's property interest?
it's not necessarily that they're defending their property interest. It's that first and foremost, they're not, World Equipment is not an aggrieved party. And secondly, they're not technically officially excluded from the bid protest itself as well. And if there are no further questions from the panel, I believe we're ready to move on.
Oh. So next we want to address whether or not a conflict exists. Now, the Federal Acquisition Regulations 9.505, section 905-2, subsection B1 says, if a contractor prepares or assists in preparing a work statement to be used in competitively acquiring a system or services, or provides material leading directly, predictably, and without delay to such a work statement, that contractor may not supply the system, major components of the system, or the services. Now, there are some carve-outs there, unless this is the sole source, which it is not, unless it has participated in the development or design work, which it has not, and unless more than one contractor has been involved in preparing the work statement, which is not the case. This was entirely a private work between WE and the state. It goes on to say agencies should normally prepare their own work statements when contractor assistance is necessary. The contractor might be in a position to favor its own products or capabilities, which is exactly what will show happened here. To overcome the possibility of bias, contractors are prohibited from supplying a system or services acquired on the basis of work statements growing out of their service. So in this case, we have that January 6th email that I'm sure the board has seen from Charlie Osborne in the state, confirming that WE played a major role in developing the specifications. The same email goes on to say that although the purchase order for your consulting services has expired, so we now know that WE was once also a paid consultant tasked with writing specifications, and now they're just a potential bidder writing the specifications on behalf of the state. The conflict in this case is clear. Next, we want to talk about the representations made by WE when this was questioned by the state.
Can I ask a couple of follow-ups before you go to the representation?
Sure.
One, does the federal law that you cited, does that apply here, or are you suggesting that as guidance?
Well, the West Carolina Procurement Code is based on the federal regulations because of the amount of grant funding, federal grant funding. So section 11-301 of the West Carolina Procurement Code covers conflicts of interest, based in part on federal acquisition regulations right here that I quoted, and also on the Minnesota statutes. So those two are the basis of the West Carolina law.
I'm not sure I understand that the same way, but that's okay. Let me ask another follow-up question. And that is, we had the January, I don't remember if it's January 5th or January 6th set of emails. Do we know when World Equipment provided specifications to West Carolina Hospital? Do we have anything more of a timeline?
We don't. As far as we can tell, the state kept this quiet. I mean, this was not a formal process. This didn't follow any agency procedures on working with contractors. This was just done entirely between two individuals within the two agencies. And therein lies the conflict. I mean, had there been some procedures in place in the procurement division, had they been followed, had this been documented and transparent, it's possible this could have been done without a conflict. But that just was not the case.
Thank you.
Thank you.
So just to follow up on Justin's question, does that piece of code, does it reference compensation for consulting work?
You know,
I mean, as I look at the, the information we have, the contract had expired. The exchange took place after the contract expired. So I'm just curious about what the code actually references in terms of compensation.
I would have to find, right. No, I understand. There was some carve out for compensated contractors because it would theoretically be possible to structure the procurement such that there was not a conflict of interest. For example, if this agency had written the specifications around the spirometers, they should have been disqualified from bidding on spirometers. It shouldn't have been involved in there. So there were carve-outs for that. However, since the purchase order had expired according to the state, that's not even an option. I mean, in this case, we literally have a proposed bidder going to the state procurement agent and saying, these are the specifications we'd like you to publish.
Now, I'm not sure if this is sort of overlapping into your next argument or not, but it's my understanding from looking at the email that we've been discussing, that there is a division of tasks at the company, and that people that are going to be participating or participated in drafting are not the ones that were involved in helping the state put it together. Does that solve any potential conflict?
You know, our position is that it does not. First of all, there was no one at WE at this point who was contracted to provide any services. So if there was another team that would have been writing these specifications, they weren't doing it on our behalf. This was one company reporting to one set of shareholders. And in the words of Abe Honett and Abe Honett, it's the January 6th email, he gives WE's position very clearly here. It's not that our consulting firm is trying to help you fix these. He says, we very much hope to be able to provide the hospital with its critically needed testing equipment in the coming months. This on the part of WE was just a play to win the contract. It's right there, plain as day in the email. So to your question, whether there was or not is unclear, because again, this thing was not transparent. There was no due diligence by the state to ensure this. It was just an after the fact cover your tracks email. I don't know if I answered that or not. Sorry, I get a little passionate about the.
No, I understand. Yeah. I understand what you're saying. It seems to me that your position is relying more on the fact that they added something to the procurement that only they could provide, or they could provide better than the other entities. And therefore you're saying that's the big issue, is that they changed it to benefit them specifically, knowing that the incumbent couldn't do that.
Right. And that actually brings me to my very next point was, as a result of WE's interference in the bid, there were two defects here. First of all, 2 CFR 200.318D states, the non-federal entities procedures must avoid acquisitions of unnecessary or duplicative items. By inserting the spirometers that we know are not necessary in this region, they've added a duplicative item. And as you were saying, 200.319 prohibits creating an unfair advantage. WE wrote the specifications such that the spirometers were added, that the state does not need, and that they know full well that they're the only ones that can provide as a large global company. So they took these and twisted them so that they would be the only ones that could provide the service. So the answer to your question, Your Honor, is yes. That's exactly what we're saying.
Okay. Thank you.
Thank you.
And who's going to be continuing with your argument?
Yeah, yes, Your Honor. I will. To conclude our argument, Your Honors, we are here today asking for two specific pieces of relief. The first is pursuant to Section 9-202, remedies prior to an award, and that is to revise the solicitation in order to comply with the law. As we've seen here, we have multiple, a conflict of interest plus misrepresentations by one bidder, and I think those need to be addressed so that way this process is competitive, open, and transparent, and so that way the people of the state get the products that they need, not at over expensive prices and not unnecessary or duplicative items that aren't going to actually further the needs of the state. So first, we are asking that the contract or the solicitation itself be revised to eliminate that spirometer requirement. It's not something that's been necessary in the past. There have been no changed circumstances presented to make a spirometer now a necessary piece of medical equipment for West Carolina Hospital. If that situation has changed, then maybe this is a different scenario, but those circumstances have. Yes, Your Honor.
Mr. Green, are you saying this board has the authority to do what you're asking, or does this board only have the authority to determine whether or not there's been a violation of the code? What authority are you saying we have?
I'm saying that pursuant to Section 9-202 of the West Carolina Procurement Code, this board would have the authority to revise in order to comply with the law. And because the law here has been broken, we believe that you do have that authority to revise the solicitation to remove those items that are not necessary. And as my colleague was saying, are placing unreasonable requirements on a firm who's part of the bidding process.
So you would have this court substitute its judgment for the department's judgment as to whether it needs a piece of equipment.
If I can, Your Honor, the West Carolina code is based largely on the Minnesota ethics laws. It's chapter 16C04 here in Minnesota, which gives the commissioner or the chief procurement officer the authority to do exactly what we're asking you to do, to order that this go back out for bid and be split.
So counsel, before you continue, I'm not sure if I'm understanding it the same way. I thought the Minnesota law is something they're looking to change to or to look at as guidance. It's not something that's currently their law.
Yes, Your Honor, that is the scenario, and we believe that is strong guidance in this space. Unfortunately, the West Carolina Procurement Code does not have the strongest language when it comes to conflicts of interest and the like in terms of ethics. It mostly focuses on state employees' actions rather than bidders. But it is our position that adopting those Minnesota provisions, which have been something the legislature is discussing, would not only create a more transparent and honest procurement process, but would also serve the people of the state at the end of the day the best. And those regulations, those statutes do give the procurement officials the ability to respond to situations like this with a strong hand.
So are you asking us to change the current law based on law in another jurisdiction? Or are you saying under the current law, we can apply what is currently on the books in a way consistent with what's Minnesota is doing right now? Are you asking for a change, or are you saying we can do it without changing the law?
We think so first of all, there is enough language in the code as written to revise the solicitation itself. Revising the law in general is probably a separate question, but we would be asking you to find the Minnesota statutes certainly persuasive as we do, but also utilizing what's currently available, which specifically says that you have the ability to revise the solicitation.
Okay, thank you.
As I'm looking at 9202, I see that as a remedy available, but I'm not sure that I see that as a remedy available with our authority. The one that is one that our board can actively enact. Can you point me to where you're seeing that as a remedy that this board has the power to enact, or is that something that happens after we make a decision relative to this particular solicitation?
Your Honor, is my understanding that the remedy allowing the solicitation or proposed to the board shall be revised to comply with the law. It was my understanding that is this board's prerogative to take that step.
Thank you.
Anything else from counsel for the protesters?
I believe that is it, Your Honors. Thank you very much for your time.
Does anyone else have any questions for counsel for the protesters before we move on to the agency's argument? Well, I'd like to thank counsel for the protester. Oh,
I apologize. Just a quick process question. Would the next set of counsel, would you like to use your slide, or would you like to go without the slide?
We're okay with without the slide. It's fine.
Very good. I apologize, Your Honor.
not a problem. I was just going to thank protesters for finishing their argument 2 minutes early. So we can move on to counsel for the agency at this point, and we're going to restart the timer. Counsel, proceed.
May it please the board. Good evening, Your Honors. Sarish Rawat on behalf of the agency, along with co-counsel Joseph Tinger. Your Honors, the protesters, they filed a protest with the board alleging several OCI and false representation violations against a potential competitor, WE. They're also wrongly alleging a lot of claims against the agency, which are incorrect in this case. The basis of the protesters' OCI and false representation claims is an email chain between the junior contracting official and the intervener here. The protester alleged that this email chain shows an OCI and false representations due to which the competitor WE should be disqualified from the procurement. The agency argues that it should not. The overview, this is an overview of our arguments. The protesters' claims, they're untimely, as Judge Kreis, Your Honor, you pointed out correctly. There's no OCI here. Firstly, the West Carolina Procurement Code does not cover organizational conflicts of interest beyond a passing reference in section R4202.01.2 of the West Carolina Procurement Code. The agency made a sound business decision as it is its discretion to consolidate this parameter requirements. Any communications with WE, either in connection with the purchase order for consulting services or otherwise, were consistent with the agency's authority to contract for preparation of services, for specification services, as mentioned with section R4202.01.02 of the West Carolina Procurement Code. The state determined that there were no substantial conflicts of interest here, if any at all, and it was in the state's best interest to consolidate this parameter requirements as it offered the state best value and efficiency in procurement. Any representations that WE made during in the email exchange, they were made in good faith, and the state, it is the state's position that WE should be allowed to compete in the interest of fair and open competition here. Moving on to the jurisdiction of the board, Your Honors, as a novel protest of a solicitation addressed to the West Carolina Board of Contract Appeals by an aggrieved prospective bidder, the board has jurisdiction to review and determine this protest de novo under section 905 and 906 of the West Carolina Procurement Code. No prior determinations of fact or law by contracting officials, in this case, are binding on the board. Determination and findings of fact made by the board are final unless they are clearly erroneous, arbitrary, and capricious. However, no determinations of law made by the board are final. At this point, I would like to turn it over to my co-counsel, Joseph Tinger, who would talk about the protester standing and the timeliness of the protest.
May it please the board, good evening, Your Honors.
Good evening.
Under section 95061A of the West Carolina Procurement Code, an aggrieved offeror or bidder may file process to the Procurement Appeals Board. Board determines not aggrieved party because they have not suffered an injury. This problem is that they claim they're unable to provide under the solicitation or readily available at local stores for purchase inclusion in the catalog. The anticipated valuation is them a price disadvantage. In that case, they should file post-award OCI issues to the FAR regulations and the competitive bid by FAR regulations. But under non-organized legal contract remedies, they give us the limitations of actions that can be applied. The process stands as WE World Equipment violated a conflict of interest in a representation which is being denied.
So how are you claiming that West Carolina Medical Equipment, Inc., the protester, hasn't been aggrieved? Didn't they previously provide this product or this under this contract, and they're bidding on this contract? And now, based on what they're alleging is a conflict of interest, something we'll have to determine after we hear from everyone today, that something's happened that's going to pretty much exclude them from participating. How's that not aggrieved?
The WCME has stated that they really don't provide the parameters, and the statement that they made, they actually are going for the bid for the contract to the state, which they want to maybe get the parameters to the summer program. Give me a second here while I locate the exact verbatim they stated.
Your Honor, while the co-counsel looks for the exact language there, is it okay if I jump in and add a point?
It's counsel, it's your argument. We're here to listen. So go ahead.
Thank you, Your Honor. I just wanted to add that, you know, the basis of the agency stating that the protester was not aggrieved is because the parameters that they say that they are unable to provide in their catalog as a part of this, in response to the solicitation, those parameters are actually available at like your local Walmart stores. They're locally available. They can easily source them from the local store and include them in their catalog, or in fact talk to the distributors that are sourcing those local.
But isn't their argument is that something nefarious happened to even add the requirement to have them? They're not saying they can't get them, I don't think, but it may be more expensive or costly for them to get them when they think they're not needed and they think that they were specifically added to benefit another person. So isn't that a factual issue that the board needs to hear from everyone before determining that they don't have, you have to say they don't have standing without knowing more about that?
I would agree with you, Your Honor. Yes.
Your Honor, I did locate that verbatim that WCME stated.
Go ahead, continue.
Yeah, okay. WCME historically benefited from the small business policy set forth in Article 11 of the West Carolina Code. However, WCME was concerned because it does not provide surroundings as part of its suite of equipment, whereas World Equipment does. So it goes to show that WCME posted a bid on the PGP website. 14 days later, WE was able to, on the open bid, locate the exchange as to the FAR regulation in the West Carolina Procurement Code, and they should be able to keep the bid.
Okay. You want to address timeliness now, unless anyone has any questions before we move on? Seeing no questions or hearing no questions, we'll move on to timeliness.
May it please the board, and good evening, Your Honors, again. Under section 9506A2 of the inflation guidelines, protesters must file a protest within 14 days. Knowing the facts and circumstances on which protest is based, filed West Carolina Medical Equipment Inc., the protest 30 days after the email exchange was formed for the base of the protest and released pursuant to the open records request was made by the Project on Good Procurement's website. And then Article 9A, legal contract remedies, to effectively review statutory 9402 time limitations of actions that's expired. The video concept hearing is as of July 21st, 2002, which is this hearing, has been scheduled. If we review the email exchange and exhibits that we could provide if needed, the authority to resolve contract and breach of contract controversy pursuant to Article 9101.03.1 following a protest, and the forms outlined for the statutory requirements, requested information, time to file, and the monetary valuation, the monetary valuation of the parameters, we could be able to determine the timeliness needed if it's the 120 day within or thereafter, after the 14 days pre-approval for the bid.
Yeah, and just to jump in there, co-counsel, would like to add, in summary here, the protester, really, they should have filed the protest within 14 days of knowing the facts and circumstances on which the protest was based.
Well, didn't they do that? They filed it within, what was it, 2 or 3 days of when they became aware of what had been posted by PGP.
Yes, Your Honor, but they were on constructive notice. So from the open public records, the information was out in the public, and they should have made the efforts to know the information when it came out.
So you proactively publish all of your solicitation documents, including the emails that the protester has referenced that was out there as constructive notice to the protester. Is that what you're telling us?
No, Your Honor. The civil society organization, PGP, had filed an essentially a state FOIA request for these documents. And in response to that, agency had released those emails. So what the agency is arguing is that the protester should have really submitted this protest within 14 days of that information becoming public. And in fact, they took
via a third party posting it. They should have within 14 days of a third party posting that information, they should have filed. Is that your argument?
No, Your Honor. From the from the agency posting, yes, the email chain initially.
So I think the confusion the court's having or the board's having is that the letters that constitute the basis for the protest didn't come available till someone stumbled across on the internet that someone else had posted it. So trying to say they know or should know something's out there that's not specifically posted to them, it comes down to the argument of, what is their required due diligence to track message boards across the board, or is the argument that they have an obligation to do their own records search or request. It seems to be asking a bit much for someone to do that every time. So I guess I'm sort of struggling with this, with what my fellow judge was asking is, you guys didn't post these letters anywhere, someone else did. How are they supposed to find them? What's their obligation?
Yes, Your Honor. So in terms of the agency publishing the email chain, my understanding was that the agency publishes the answers to any open public like FOIA requests. But I can certainly double check and get back to you.
Yeah, I don't think that's what happens. If there's a FOIA request, the documents are usually produced to the person who requested them only. And then, like I said, in this case, they did then post them publicly for other people to see, but they weren't specifically sent to any of the other people that are involved in this protest. So they ultimately did their own due diligence and found it and then quickly filed a protest. But I guess we're struggling with how much of an obligation they have to sort of investigate to figure that out. Now, I'll tell you that's something that comes before boards regularly. Have had cases recently to deal with that issue. So, but yeah, I don't want to take up too much time unless anyone else has other questions on timing, because we are sort of running out of time. We have about 9 minutes left. So if you guys want to move on to your remaining arguments.
Yes, Your Honor. Moving on to the appropriateness of WE's intervention. Your Honor, the basis of the protesters' OCI and false representation claims are based on an email chain that was filed. Let
me just ask you the question: should they be able to intervene, or shouldn't they be able to intervene?
They should be able to intervene because they're in the best position to answer a lot of the questions that the board may have this evening.
Okay, and that's your reasoning. Are there any other reasons why they should be able to intervene?
Your Your Honor, the code, the West Carolina Procurement Code, it only mentions intervening in passing, but I believe in our situation, the intervener must be allowed to intervene here.
Thank you.
And moving on to the disqualification, it is the agency's position that WE should not be disqualified due to an organizational conflict of interest. There is the West Carolina Procurement Code does not cover organizational conflicts of interest beyond a passing reference in section R4202.01.2 of the West Carolina Procurement Code. It is our position that the agency made a sound business decision, as it is its discretion in this case to consolidate this parameter requirements. As I had
Sound
mentioned,
business decision based on information provided to it by whom?
Your Honor, the decision was not, while the decision was made after we received information from WE and their suggestions, it was not solely based on the information they provided. The decision to include was a business decision that the agency took after taking into account a variety of factors.
Did anyone other than WE know that the procurement was going to require something additional this year, requiring the spectrometers? Did anyone else know that before it came out?
Your Honor, not before it came out, and even WE did not know that we were going to include the parameters in the requirements until it came out. We just suggested that, you know, as the email chain suggests, that we took their suggestions and we made a decision completely separately.
Continue.
Yes, Your Honor.
And I apologize, but if I may interrupt as a follow-up to that, and I know
Absolutely.
you will keep going. There's an interesting balance here, right? So you're arguing that there's no organizational conflict of interest because it's not recognized in code. But I would be hesitant to believe that the agency is arguing that suppliers should be allowed to help the agency draft its solicitation document. Am I correct?
You're correct, Your Honor. We're not arguing that at all. We're saying that the agency made a sound business decision based on its procedures that it usually follows. There was a separate consulting contract with WE on which is in consistence with the code. And within the WE organization, as you will hear from the intervener, I'm sure they had their own procedures for firewalling information from the consultants that actually helped provide us with suggestions on what to include in the.
So let me ask you this question. If you hire Coca-Cola as a consultant, what's the likelihood that they're going to give you specifications that allow you to buy Pepsi?
Your Honor, in terms of from that example alone, I would say the likelihood is less, would be on the lower side. They would of course have a conflict of interest there, but in our case, it is a completely different set of facts. The parameters, they did not, like I was saying, they are available for anybody to include in their bid.
Forget the parameters for a moment. I'm just asking the simple question of their involvement in assembling any of the specifications and whether that raises the similar analogy to what I just presented with Coke and Pepsi, right? That you have one person, one entity that you're asking to develop specifications, and what is the likelihood that they're going to develop specifications to their own favor?
Yes, Your Honor, I agree that the likelihood there is high that they would develop specifications that would favor them. But as I was saying, it is the agency's position that the West Carolina Procurement Code, it does not cover organizational conflict of interest beyond a passing reference.
Thank you.
But if you take his question a step further, even if they're recommending what is best for the state, in this case, if what was best for the state is something that benefits them or benefits, hurts another company that's already participating on the contract, we clearly know that they provide this item. The incumbent didn't, or the protester didn't provide this item. And we know that the item is very seldom, if ever, used in this area. So even if out of an abundance of precaution, the state would want this item available to it, does it matter whether there's an actual impropriety or there's an appearance of impropriety enough?
I would agree with you and the state regulations, the state legislation is considering passing, conflict of interest regulations similar to those in FAR 9.5 and those in the Minnesota state regulations that would prohibit such a situation. Like I was saying before, it's the agency's position that the procurement code currently does not cover conflicts of interest, organizational conflicts of interest beyond the passing reference.
So
Is it your suggestion that this board cannot interpret the possibility of a conflict of interest beyond what's specifically authorized in the code? So in other words, are we limited to only the passing reference, or are we free to consider the actual application of
that was going to be my question also. Great job.
Great mind, right?
Respectfully, Your Honor, you would it would be the board's authority would be limited to what is included in the West Carolina procurement code.
So can I ask a quick question?
Absolutely.
So just from a practical perspective and, like looking at best practices, did your team conduct an RFI? Did you have any communications with other prospective suppliers? What other market research did you do in advance to develop your specifications?
Yeah, so the state followed its procedures for procurement as it does in every solicitation. So that would be, we conducted our basic RFI. Those are facts that were not that are not included, but it is the state's position that we followed a standard procedure for procurement in this specific procurement as well.
So you would tell me, if you had the facts, to tell me that you confirmed that there were multiple suppliers who could supply the entire suite of goods?
Were there facts? Yes. That's what I would tell you, that there were that we had looked for at least 2 small businesses as well.
And just to follow up on Sarah's question, regardless of whether or not other companies can provide this product, at what point does the unfair or unequal opportunity to provide input on the solicitation development process by itself constitute an unfair advantage?
So according to the code, it would have to be a substantial conflict of interest, and in this case, it's the agency's position that the information provided by the intervener did not amount to a substantial conflict of interest.
And you didn't think that would have been, that there was a substantial conflict of interest, especially considering the email that was sent by one of your contracting officers about the appearance of there not being an independent or impartial process here?
Yes, Your Honor, that's the state's position.
Just a quick follow-up, if I got time. Is the state's position that it's okay for there to be a conflict of interest so long as it does not rise to the level of substantial conflict of interest?
No, Your Honor. It's the state's position to follow its procurement policies and standard procedures that it does in every procurement, as it did in this one here.
Thank you.
your time actually has expired, but I'm going to let you wrap up with your requested relief.
Yes, Your Honor. Thank you, Your Honor. In conclusion, agency requests that in the interest of full and open competition, WE be allowed to compete in the solicitation. We request the board to dismiss the protest as untimely, or alternatively dismiss WCME's protest after finding that WE need not be disqualified due to conflict of interest issues, and allow the procurement to proceed as planned by the agency. Thank you, Your Honors.
Thank you very much. And now we'll move on to the intervener's case.
Thank you. May it please the board, my name is Keith Montoya. I represent the awardee in this matter, Intervenor World Equipment, also known by the acronym WE. I am joined by my co-counsel, Christopher Eukins, and he will be sharing, the presentation, but we didn't do the presentation. As you know, World Equipment is a large international provider providing a wide range of equipment and supplies to help to meet the needs of not only West Carolina Hospital, but other medical facilities worldwide. It is our belief that the procurement process conducted by West Carolina Hospital was in fact fair and reasonable manner and in the best interest of the state. WE has implemented its own procurement system and follows those procurement and policies and procedures in line with that of West Carolina procurement policies. Today, we will provide clarification as to why the procurement process conducted by West Carolina Hospital for medical equipment and supplies was conducted properly without conflict of interest and per those rules and regulations in place. And WE should not be barred from participating in this procurement process. Currently, the protesters' core argument here is that the procurement strategy was unsound because it required to include a spirometer. Respectfully, we disagree. The procurement strategy here was sound. The cost of administration of multiple contracts outweighs any potential benefits of fragmenting the requirements. And the multiple awards were not in the best interest of the government. A spirometer is a commercial item which is available at any Walmart. It's easily available, readily obtainable. Therefore, respectfully, protester could have solved its problem by a simple trip to a local Walmart to purchase it,
So counsel,
rather than bringing this.
Counsel,
Yeah.
WE, do they produce this item or do they go buy it from somebody else?
Based on the information, I believe it's we purchase, we're a middleman, we're a distributor, so we sell it, we do not produce it.
Okay, but it's something your company already has a connection with, it has someone to procure it from?
Yes, Your Honor.
So
we procure for someone else and turn around and resell.
But wouldn't that give you a competitive advantage if you're already set up to do that versus someone else having to go out and for the first time initiate a subcontractor with someone else to purchase them or to buy them and resell them? Wouldn't there be a competitive price advantage potentially for your company?
Well, as mentioned, Your Honor, previously, being a worldwide, yes, we do have supply chains in place. We do buy larger quantities and we can sell at a lower price. That being said, the spirometer was readily available for them to purchase and easily obtain, whether it be Walmart, CVS, or anywhere else. As far as price, you know, this spirometer can range from $3, a mere $3, to quite a bit more depending on the model and type they wish to buy. But it was something that they could procure they could procure and provide readily.
But this case does not, to me, hinge on whether West Carolina medical equipment can provide spirometers or any other piece of equipment, but rather on whether the inclusion of that specification was a pretext to the benefit of World Equipment. And that to me is really where the question is, but I'll hold off on that until we get perhaps to the organizational conflict of interest question.
Yes, Your Honor, we will dive a little bit more into that detail further on in our discussions.
Okay, continue.
Okay. As we will discuss in further detail, and as the agency has already explained, the protest was already clearly untimely. Under the laws of the state, protesters claim that there was an organizational conflict of interest is completely baseless because a contract to prepare specifications, the necessary ingredient for any organizational conflict of interest under the laws of this state, simply do not exist.
So
At
is
this
it
time,
your-
I'll hand it over to my, I'm sorry, go ahead.
So is it your position that it would be impossible for there to be a organizational conflict of interest if the state did not pay for that consulting? In other words, if a salesman comes in and says, here's the specification for my product, you should use it, that the state then using it would not be subject to that ban, that there would not be an organizational conflict with that company then bidding on the thing that they gave the specification to?
That is correct, and we will once again dive into that a little bit more in the next section, Your Honor.
Okay,
Thank you.
I think you were about to pass it on to your co-counsel.
Yeah, I'll just briefly, Your Honor, I'll address the issues of jurisdiction and standing. We concede the question of course, of the board's jurisdiction. Just on the question of standing. Well, technically, protester has standing as a bidder. We want to just really stress here that their standing as bidder turns really on a very, very narrow issue, very, very narrow question. The protester standing to complain that this procurement is based on an organizational conflict of interest or some sort of prejudice in the solicitation is based on only one fact, which is that the protester doesn't offer spirometers. But as my co-counsel has explained, spirometers can be as inexpensive as $3 or $4. It would have been in order for the prejudice and the standing to disappear for this party, for the protester. All the protester literally would have to do is go to Walmart and buy a spirometer for $4 or $5. So that it's a very, very narrow read here because the grounds for their protest are really so narrow. They just failed to go to Walmart or CVS or any other number of countless places where you can buy a spirometer on the open market. I'll turn it.
But counsel, doesn't it go doesn't there protests? I mean, I guess you need to understand, I guess, look at how much leeway you give to what a protest actually says, I guess, because the question would be, does the protest go as far as to say that the need for these to be part of this procurement at all is part of the conflict of interest, that the only reason they became part of this is because WE wanted them there, knew they couldn't provide them as easily, that the protester couldn't provide them as easily as your client could, and they really didn't belong in here because they're really not required in this area?
Well, if I could, Your Honor, if I could break that question into two parts. One is what's inside the agency's head, and the other is what's inside our client's head, so to speak. In terms of the agency has enormous discretion on what they do or do not include in the specifications, and understanding the perspective of our client, WE, would our client reasonably have believed that adding a $4 spirometer would actually preclude somebody else from competing? Would that be their corporate strategy? Oh, $4 spirometer will mean that we win this. There's no way that could be a reasonable understanding on the part of our client. Our client would not. That's not a reasonable corporate plan. So the fact that the spirometer was included was just a matter of the agency exercising its discretion to have a comprehensive specification.
So I'm not sure. Can you help me understand two things there? So number one, you're saying that if somebody came up with a very inexpensive, clever way to limit competition in their favor, that would not be a good corporate strategy. In fact, maybe that would get somebody promoted to vice president if they could get a contract for a $4 item. The other piece that I'm not sure if I'm understanding, are you saying that the idea of conflicts and by connection, the idea of ethics is based on how much rather than what happens? So
No,
if
you're-
it's only a few dollars, then it's not an issue to be considered because it could be corrected with a few dollars.
No, Your Honor, the core of the questions that were being put to my core counsel, Mr. Montoya, was, does this create a perception of unfairness in the general public? And that's a very legitimate concern for any government to have. Does it look like it's acting in an unfair manner? But any reasonable person who is told, oh, the only difference in this specification was that a $4 spirometer that you could buy at Target in 10 minutes, that's the only change. No one's going to think that that procurement process was actually distorted in any material way. So there's no potential for perception of unfairness or corruption. That's through a $4 spirometer. It doesn't make any sense.
Right, but the follow-up, you had answered in two parts. You said from the agency perspective, the agency has great discretion about what it puts in and doesn't put in. It had never put spirometers in previously, had it?
No, Your Honor, the facts are that it had not, partly because they're used so infrequently.
Right, but exactly, they aren't used frequently and they've never put them in before. And then we have a communication from your client to the agency and then they're included. And just by coincidence, the person who had the project or the contract before now thinks it's being excluded or whatever. Again, it goes to not necessarily the magnitude, but to the communications and the procurement laws were put in place to sort of avoid backdoor dealing, paper bags of money and things like that. I'm not saying this is a paper bag of money, but isn't this a big company sort of using exclusive contact with the agency to gain a competitive advantage?
Well, there's nothing in the record, Your Honor, that would suggest that the WE actually suggested the spirometer. We just don't know that.
So let me clarify here if I can, Counselor. Do we know that your client is even the one that recommended the inclusion of spirometers?
No, there's nothing in the record on that point, Your Honor.
There's nothing in the record, right? And the reason I'm asking that question is, again, I don't know if this is about the spirometers, if this is about the pretext of the spirometers, or if this is ultimately just about your client's involvement in the writing of the specifications. And so I think that's where the question comes in, even though we're just talking about protesters standing at this point. I don't think the argument here is limited, nor do I think the protester limited the argument to just being a question of the inclusion of spirometers.
Well, it's undue access is the question.
I think that's a fair way of putting it. Undue access, unfair competitive advantage, right? These are the issues before us.
If I could, Your Honor, you're absolutely correct. But part of the question for any protest was whether or not the protester was actually prejudiced. And the only prejudice that the protesters put forward here is the fact that it doesn't offer spirometers. But again, that's a trip to a Target.
And is this board limited to that consideration?
If the board finds that there wasn't a genuine prejudice, then the protester lacks standing. Under procurement principles of standing, it lacks standing because there's no prejudice.
So we have to get to the end to determine whether or not they're standing.
That's correct, Your Honor.
And circle back to an example used by my colleague earlier. Coca-Cola is widely available, but if they provided specifications for Coke and Pepsi wanted to bid, would you argue Pepsi is not prejudiced because they can go purchase Coke from a Walmart and provide it?
If again, those aren't the facts, Your Honor. The facts are only that there was a discussion of what our best practices in the marketplace, and my co-counsel is going to address that. And there are spirometers that the protester doesn't provide. That's it. That there was general counseling on one hand, and the other hand, $4 spirometers are not provided by the protester. That's it.
Thank you.
Okay, thank you.
Mr. Montoya, I'll hand it back to you.
Thank you. Excuse me, timeliness for the protest. So this was discussed previously. We referred to section 9-506, protest of solicitations of awards. The scope. This section applies to a protest of a solicitation of award of a contract addressed to the Procurement Appeals Board by an aggrieved actual or prospective bidder or offerer or a contractor. And B, an appeal addressed by the board of a decision under section 9-101, part 3, authority to resolve protested solicitations and awards decisions. Part 2, the time limitations on filing a protest of an appeal. For a protest under subsection 1A of this section, the aggrieved person shall file a protest with the board within 14 days after the aggrieved person knew or should have known the facts and circumstances upon which the protest is based. As discussed earlier, the deadline for the protest for the board is therefore 14 days after the protester knew or should have known of the relevant facts. Here it is uncontested that the protester did not file its protest for a month after the information regarding the alleged organizational conflict of interest was posted, and even longer after the solicitation was posted. The protest, therefore, was untimely in this case.
Well, we asked the same question to the protester. What is your response to the question as to what their obligation is to search nonprofit message boards to find out whether or not something happened in their procurement?
I'm sorry, could you repeat that, Your Honor? I apologize.
Yeah, I said we asked the same question to the protester. I guess the question is, what is the obligation for them? They didn't have it for a month before the protest. They found out about it when they found it on the site 2 or 3 days before they filed their protest. It had been on the site, but what was their obligation to locate it? That this goes to the, we know when they actually knew. So we're arguing about the should have known. Why should they have known this was on someone else's website?
If
I'm sorry, Your Honor.
If I could, Your Honor,
Yes.
Mr. Montoya, can I jump in, Mr. Montoya? Is that okay?
Yes, please.
So, Your Honor, I think what we're doing is we're flipping the burden of proof upside down. It's the burden on the protester to show that it has standing, okay? And if the protester position is that it didn't know about something that was published on a website, it needs to explain why it didn't. It's never done that. So we know the facts were publicly available. Anybody could have found these facts, and the protester hasn't offered any information to explain why it didn't come forward at that point. Also, importantly, Mr. Montoya pointed out the solicitation was published much earlier. If the real core of their concern is that the specifications are unfair because they include products that the protester doesn't offer, the protester should have protested within 14 days of the publication of the solicitation, and they didn't do so.
But doesn't that get down to what the protest deals with? Because if the protest is the specifications are unfair, because remember, you just argued earlier that there's great discretion for the agency to put whatever it wants to in its procurement. So, at the point when the solicitation came out, they could have looked at it and said, I guess they've changed their mind. This is what they want. And there's not really a basis to protest. But then they see this letter and these communications going on behind the scene, and they say, wait, this isn't necessarily what the state wanted. This is something that one of our competitors convinced them to put in. Isn't there a difference between those two protests?
You have to ratchet it back, Your Honor, and look at it through the perspective of the protester. From the protester's perspective, it can't compete because it doesn't offer a $4 spirometer from Walmart. That didn't change from the time that the solicitation was originally posted. Within 14 days, it couldn't compete during those 14 days. That situation didn't change till when later on the communication that we're discussing here was published. The protesters' competitive position was the same throughout that period, and they should have protested at the beginning of the period within 14 days.
Is there not a difference? I'm sorry, go ahead.
Oh, I was going to say, if you're looking at it as, if we look at the argument the chief judge made a second ago, which is they looked at it, they said, oh, they changed their mind, it's within their discretion, maybe that's okay, so I'm not going to protest now, and then they find out there was this alleged conflict. Is it your suggestion that they had some positive obligation to investigate the reason for changing their mind when they discovered that they would not have the entire spectrum of supply?
Yeah, that positive obligation is called a protest. If they believe that the specifications were unfair, they should have brought a protest within 14 days. This rule is extraordinary. The rule calls for rapid protesting. The federal rule is different. You can protest until the moment before bids are due in the federal system. This rule in West Carolina is intended to prompt protesters to move quickly, to prompt vendors to protest quickly, and they ignore that obligation.
I don't believe that the protest is on the basis of the inclusion of the spectrometer. I just don't buy it. And this is my question, right? Is it the inclusion of the specification, in which case they should have protested within 14 days of the publication of the solicitation? Or is it the inclusion of the specification based on the input of a competitor, based on specifications provided by a competitor, which they did not know about until a later date, thus start in the beginning of that 14-day period? So that's the question at hand, right?
They were the two scenarios I set out also. I agree.
I don't disagree with you, Your Honor, but the problem is that their argument is the procurement is unfair because spirometers are included because there was this adverse impact. Okay, so there's no way to skip the fact that the core of their argument is the fact that spirometers were included in the specifications and they don't provide spirometers. Because if we ignore that, they have no standing whatsoever. If they provided spirometers, they have no standing.
So to the extent that a protest that seeks to allege wrongdoing by a state agency is not well articulated, we should ignore any impropriety performed by that agency?
Not at all, Your Honor. What I'm saying is that if a party that feels aggrieved is allowed to sit on its right past the 14-day deadline, the entire protest process that was envisioned by the legislature here falls apart.
Right, but both the protests filed by them alleged both an organizational conflict of interest and that the representations that were made by and that there are representations made to WCH. So that goes more to the conflict of interest issue that Judge Kaufman was talking about than it does to the spectrometers or whatever we're dealing with here. So it really is, the protests as set forth, or the protest as set forth is dealing with the organizational conflict of interest and the representations, not the inability to provide them. So like I said, I think we've addressed this issue pretty thoroughly. We do have more to hear from you, and you have about 1 minute and 20 seconds left of your 24 minutes. So we'll give you as much time as you need, but let's move on to the next issue.
Very good. If we just quickly address intervention, as the agency noted and as protesters discussed, intervention isn't really discussed in any detail in the Model Procurement Code. There are two references in the Model Procurement Codes in the West Carolina Procurement Codes implementing regulations to intervention. Both of those passing references are to the fact that the intervener should receive notice of the decision. The West Carolina rules are based on the Model Procurement Code, as I've been suggesting, and the Maryland rules, the Maryland Board of Contract Appeals, State Board of Contract Appeals rules are also based, according to the discussion that we've in a prior session with Michael Carnahan, who's one of the newest members of the board, noted that the Maryland rules are also based on the Model Procurement Code. The Maryland board has guidance. It's very important guidance, which says that if there's a gap in the Maryland rules, that we can look to the Maryland's rules of civil procedure to try to determine how the process should unfold. And the Maryland rules of civil procedure follow the federal rules in discussing intervention. Under the Maryland rules of civil procedure, when the person claims an interest relating to the property or transaction that is the subject of the action, and the person is so situated that the disposition of the action may, as a practical matter, impair or impede the ability to protect that interest unless it is adequately represented by existing parties. In this case, there are any number of interests that could be implicated on the part of the intervener that are not adequately represented by the agency. Simple fact, the agency could decide in 10 minutes to take corrective action. If it decided to do so, the intervener's rights are not being protected. So the intervener has contractual, statutory, and constitutional rights that are not being adequately protected by the agency. And the intervener therefore needs to have an opportunity to intervene in this action. Thank you, Ron. I'll turn it over now to Mr. Montoya to close out on the organizational conflict of interest issues.
Thank you.
Thank you. Your Honor, currently with Carolina procurement regulations, which are based on the NPC recommended regulations, do not cover organizational conflicts of interest beyond the reference of section R4-202-01-2. That section does not apply here because there was no contract to prepare specifications. Section R4-202-01-2 provides the authority to contract for preparation of specifications, including design requirements. Section A, when a written determination is made by the head of the purchasing agency authorized to prepare such specifications that there is no substantial conflict of interest involved in it, is otherwise in the best interest of the state. A contract to prepare the specifications for the state use a procurement of supplies or services may be entered into provided such officer retains the authority to finally approve those specifications. Part B, whenever it is determined under section 5.203, choice of project delivery methods of the state procurement code, that the selected method of delivery for a project requires specifications, including as appropriate design requirements as defined in section 5-201 of the state procurement code to be prepared by other than the state personnel. A contract may be entered into such preparation provided the head of the purchasing agency retains the authority to finally approve such specifications and design requirements.
So, counsel, would you concede that one of the purposes of procurement regulations is to encourage competition and fairness amongst the competition?
Yes, Your Honor, I would.
Okay. With that in mind, you just cited to us conflict regulations, which you say really aren't applicable. So is it the intervener's position that if actions were taken that were unfair and limited competition, but weren't specifically prohibited in that section, there's nothing to allow for this board to take action?
It is the board's authority to take action, but I was just clarifying that I apologize. I'm looking for that page real quick.
That's okay. In essence, what I'm asking about is outside of procurement law, when you deal with contracts, there's an obligation of good faith and fair dealing. Is that part of the procurement code also? Is there something?
Yes, it is. I mean, I'm sorry, Your Honor, go ahead.
I say, is there something, I guess, broad enough within the code that would allow us to deal with this issue, although it's not in a section labeled conflict of interest?
If I could, Your Honor, on that point, the rules regarding organizational conflicts of interest have to be very precise. You can't take a general principle like competition or good faith or fair dealing and project it forward into the marketplace, because as the federal experience has shown that companies make billion-dollar decisions about whether or not to compete in certain marketplaces based on the very closely drawn organizational conflict of interest rules at the federal level. If you not only will the companies make wrong billion-dollar decisions, but the amount of competition available to the state will be gutted if the companies can't rely on a clear set of rules. So if to apply a general principle of competition or general principle of good faith and fair dealing without the specificity of real rules, and they don't exist yet, without specificity of those rules would be very disruptive to competition before the state.
So that I have it clear, I just want to make sure that World Equipment then can affirm that as long as the agency does not pay West Carolina Medical Equipment for the next solicitation, they're okay with West Carolina Medical Equipment providing the agency with the specifications for the solicitation, and that World Equipment would respond in that protest. I just want to make sure I had that clear on the record.
Right, right.
The question is whether the real, and this is really something that's very durable in the rules of organizational conflict of interest. If you look at state practice across for instance, at Minnesota, or you look at federal practice or even international practice, the question is whether or not there's an unfair competitive advantage. There's been no showing here that the work that our client did with the state actually created an unfair competitive advantage. If, to go back to Judge Beavis's example early on, if a contractor passes in its specifications and the state uses those specifications, that may well create an unfair competitive advantage, but that's not the showing it. That's not the facts here.
Council, we've gone over the time. I'm not sure where flexibility is. I'm happy to listen to more argument, or you want to conclude with your requested relief or move on to the discussion. Whatever you think the best use of time is. It's about 7:36 right now.
If we could, Your Honor, if Mr. Montoya could wrap up, and then we could take what's euphemistically referred to as a bio break for 5 minutes.
Okay, sounds great.
Absolutely. So as mentioned, even in the grant, or the rules did apply, the hospital's actions were completely appropriate. Section 2 CFR 200-319B states that contractors that develop or draft specifications, requirements, statements of works, or invitation for bids or requests for proposals must be excluded from competing for such procurements. However, here, WE employees did not draft the specifications, requirements, statement of work, or any part of the solicitation, but merely conducted a discussion, as mentioned earlier, similar to that of any company discussing with subject matter experts, trying to get information. The discussions were made by the employees who had special understanding of the medical equipment market, and those employees were not those who worked on the client's contracting team. No WE employees had made any recommendations or were part of the procurement or solicitation process overall. And as per section 200.318, no gratuities, favors, or anything monetary value was received. And at this time, if you don't have any other questions, I'll proceed to the next section.
Continue, please.
So, thank you, Your Honor. So the alleged misrepresentation, given the laws and the facts, WE was not in violation of any organizational conflict or interest rules. Therefore, there was no possible basis for any misrepresentation regarding an organizational conflict of interest, and WE should not be disqualified.
Thank you.
All right. And finally, wrapping up, I want to thank you and the board for the opportunity to present our case on behalf of WE today. Today, we presented that West Carolina, as well as the WE procurement rules and policies, were followed. Purchasing agency authorized such specifications. Federal grants guidance do not apply to the solicitation. Protest was not filed in a timely manner as per the MPC. Protest was filed based on a product that is readily available and easily obtainable, as discussed earlier. In conclusion, this protest should be dismissed and we should be able to retain the contract as the protest was untimely and the existing laws were not fully met.
Thank
you for your time.
Thank you very much. Yes. 5 minutes. We're going to take a 5-minute break. It's 7:40. We'll come back on at 7:45.
Thank you, Your Honor.
Thank you.
So I'm going to stay out of role and go back to being a professor.
Okay.
So much safer. A very nice job. All of the advocates, very, very nicely done. Thank you for doing that. It's
That's asking something for people to put in the time to prepare a trial that's not a real trial after they've been practicing for a while.
Yeah, it was really, you guys did a very good job of bringing the arguments together and really making cogent positions. A lot of the purpose of all this was to bring out problems in the model procurement code, because so many of the people who are judges here this evening are working on the model procurement code revision. So I really appreciate you having done that. I have some specific comments that to just put out there. The one of the things that we talked about in the preparation with the group, and you don't know this, Larry, is that and you did this all very well. For non-lawyers, it's difficult to sometimes understand how the mechanics of a courtroom work. And an American courtroom, because of the three branches of government, the judicial branch is the most fragile. There's an enormous amount of deference shown by lawyers to judges, and it's not because the judges are mean, but it's because the lawyers are very conscious of what a fragile institution this is. And you guys did a really good job of being respectful of the judges, and that's really important to understand. I've actually had classes, Suresh, I don't know if you saw this, but in the state and local seminar, I've actually had non-law students yelling at the judge during a mock bid protest in front of the DC Contract Appeals Board. So I was very glad that we were able to present as we did. Some of the key issues that we talked about on the timeliness issues, the OCI issues. The timeliness is really a coin flip. Some jurisdictions use timeliness, a requirement to protest within a certain number of days. Some jurisdictions, such as the federal government, says you can protest up until the time that proposals or bids are due. And that's really a coin toss in their policy arguments that go both ways. Something we're likely to discuss, at least in passing, is in the Model Procurement Code reform process. The intervention standards, the reason I use the Maryland intervention standards to try to fill in that gap in the Model Procurement Code is that very quickly Maryland sweeps sideways into the civil rules of procedure, the rules of civil procedure, which are based in the common law with the idea that you should allow intervention if a party's interests aren't being represented. And that's why awardees are given that right. On the OCI, those organizational conflicts of interest issues, as Judge Kreis was referring to, those are becoming more and more acute in a crowded marketplace. And it's going to be very important for us in the revision of the Model Procurement Code to really to come up with real rules. Even the federal rules are in flux. The federal rules were first written in the 1960s during the Kennedy administration. They really didn't change a lot when they were put into the FAR in '84. But now, because of various scandals that have been going on, the federal rules themselves may be revised. There's at least 3 pending pieces of legislation involving organizational conflicts of interest right now in the Congress. And one of the leading ones is pushed by Senator Grassley, saying that the organizational conflict of interest rules should be changed to, in appropriate circumstances, require contractors to disclose. And that's what we're veering close to here, the obligation to disclose organizational conflicts of interest. What was the stuff that you saw in the facts regarding the propriety of what World Equipment does as a company, that's kind of the tip of the iceberg and something that we didn't go into deeply in the facts. But what will be really interesting, this is for Mike who's going to be an NPC reporter. What's really interesting is the flip side of the OCI debate is the compliance debate. Most sophisticated contractors will have OCI policies internally on how they do, just like a law firm has conflict of interest policies. Most sophisticated contractors have the OCI practices internally, and they're really an offshoot of a broader compliance program inside those. So it may be unfair in the marketplace to expect contractors to have OCI mitigation systems internally unless they have compliance systems in place. So one of the things we'll be discussing in the NPC reform is whether or not, just as under the federal rules and just under the federal sentencing guidelines, the contractors should have internal compliance systems in place, because those internal compliance systems can be changed very slightly to make sure that they're not organizational conflicts of interest. It's just a child of a regular compliance system is an OCI mitigation system. I'll stop yakking. I'm sure the other judges have other comments.
Well, I found the problem when I first read it very interesting because, most of the issues that were raised in this problem, we've actually had to deal with as a board. And I see down below that one of our participants today is Ms. Hoover. And Ms. Hoover actually argued the organizational conflict of interest case in front of our board on behalf of the state. I think I issued the second opinion. The first, there were 2 opinions. The case, there was a procurement, they were precluded, they protested, their preclusion was upheld, they didn't appeal it. There was another issue with the procurement, so they had to resolicit. When they resolicited, they protested again because they were told they couldn't participate. This time they didn't file a protest, so we had a whole standing issue in front of us because they were not a prospective They were not a bidder or prospective bidder or contractor. So we've had this whole issue because Maryland has sort of gone a step further. We used to have a regulation that talked about you can't participate in procurements if you participate or assist in drafting in our ethics provisions, and it would go to the ethics commission, which made no sense because you had the procurements and the protests in one area and the conflict in another area. So then they moved it over to the procurement regulations, and that the case I was telling you about was the first time it actually came for a written opinion. But even with the, even though we've gone far further than the model code has gone, we still had issues of there's no definition of what assistance in drafting is. There were a bunch of things that the section says aren't, but doesn't say what it is. And then a lot of the other issues we had tonight, whenever we deal with standing and timeliness, a lot of times we end up with, sort of cart and horse issues. Is someone aggrieved? Well, that's a lot of times a factual question, which you can't determine until you actually have a evidentiary hearing on the issue. Timeliness, should have known, factual issue a lot of times. So it's a really difficult balancing act of trying to, part of the procurement process is to try and make things move at a faster pace with less formality than regular courts, while still providing adequate due process protections. And it's, the protests, especially because there's an interest in state moving forward and awarding contracts, there's also the interest of protecting the people that are participating in the process and trying to get them. So it's a real balancing act. We don't really have an intervener issue in Maryland because in this case, they would be defined as an interested party. They would just file something that say they're participating as an interested party and they're in the case. So that wouldn't even be an issue in front of us. That would have been a really easy issue. But like I said, it was, we've had this, like I said, if anyone's ever interested in opinions deal with this, on our website at the Maryland State Board of Contract Appeals, we have all our opinions. And the one opinion is from 2019. It's MSBCA 3108. And then the follow-up opinion about the standing issue is from 2020. It's MSBCA 3148. And in both of them are in the appeal of MGT Consulting Group, LLC. And they really deal with these issues in a lot of detail. So it might be something you'd be interested in looking at some point. Not because I wrote it, because I don't care about that, but it is, applicable to this. And the attorneys did a very good job, in the first case, arguing a full trial, and in the second case, arguing, or I'm not sure we argued motions or not, but they filed motions in the second one at least. Mm-hmm. So it's two separate opinions that deal with conflict of interest, whether you can participate, timeliness, standing. So it's a really good way of sort of getting an overview of what's out there, but even that probably needs fine tuning of how to do those things.
Lydia Hoover's been giving us the citations, Larry, and I've been posting them in the chat, and then the public chat becomes part of the record. I'll post that on the website tomorrow morning. Mike, did you have some observations from an MPC standpoint?
Well, there are a couple of interesting concepts for me, and of course we need to deal with this idea of organizational conflicts. As I look at it from my perspective as a person who on a day-to-day basis is trying to develop local businesses and find ways to enhance participation of small women and minority-owned businesses, I listen to this idea that we need these complex sets of rules that will allow the mega companies to have more influence over local activities as somewhat contradictory, right? Just like that fundamental premise that the decision to have fewer contracts with larger contractors is true in the private sector as potentially a valid and desired thing. You talk about eliminating the long tail economically, but in the public sector, we frequently look the opposite way and want to develop the long tail because we're trying to develop small women and minority-owned businesses and do other kinds of social equity activities, and developing complex rules that allow the big companies to have more influence is an interesting conversation to have, right? Are we filling up the world for the K Street lawyers, or are we building it for the mom and pop stores to be successful? Yeah. Or is there a conflict, or can you do both? right?
What's interesting, Mike, and is that from an academic standpoint, so the supply chain world and the public procurement world have always been separated. And in the
Right.
supply chain world, supply chain risk analysis is just road. I mean, it's just highly
Right,
routine
right.
within any given industry. In the public procurement world, we've stayed separate. And I think you're highlighting the fact that supply chain risk in the public procurement world includes considerations of the social and political considerations that you're raising.
Right.
That's why
it's a
the two
completely
worlds are
different
always
issue,
separate.
right?
Yeah.
That's why we're usually more, public procurement is more social policy and public administration than it is supply chain.
So
Yeah.
during the arguments, and I can't remember who raised the issue, but I think it may have been one of the protesters' council about the relief they were requesting, about they wanted us to modify the procurement or
Right.
modify the solicitation or whatever it was. And I asked a question there, and that was my sort of my Maryland background coming back into it. I'm not as familiar with what the model code allows or doesn't allow. But with us, one of the difficulties we have is we can't tell people what to do or not to do. We get a protest, we either say that the procurement officer did it right or they violated the procurement law. You know, their decision was arbitrary, capricious, unreasonable, unlawful, whatever it is. We can't say it's unlawful and modify this. It goes back to the procurement officer or it goes back to BPW to decide what they want to do. But we can't instruct to people. We don't put remedies out there. We just say there's a violation.
And some states can do that. The individual that hears the protest has the ability to modify the outcome, not just to say yay or nay on whether it was properly done. So that really varies by jurisdiction.
Right. And it goes to judicial activism concepts, right? Should the judge be making the final decision or making a remand to have the administration do it properly?
Right. And that's what we do is, you know, we say it is violated or not violated. And, you know, at that point, the agency can decide what it wants to do, or someone can appeal it to the circuit court or, you know, beyond that eventually. That's how we get our reported case laws when people appeal us. So.
Right. But the question is, does it even get to that level? Right. So, I mean, there are some states that have, I mean, there's no protest rights in some states.
Right.
And there are other states where it's handled at the procurement level, it's handled at the director level. So, I mean, there's a wide variety out there, you know, in terms of how these are handled.
Well, and it's interesting in Maryland, you know, although, you know, we're board members, but we sort of serve as quasi administrative judges, but we're technically appointed as board members. And our board is actually part of the executive branch, not the judicial branch. So, you know, we're dealing, you know, if we were to have an issue that required an attorney to represent us in front of BPW or whatever, our attorney would be the Attorney General's office, which is the agency that appears in front of us representing state agencies. So it's a very interesting sort of back and forth. And like the regulations that implement the code, some of the regulations we have control of modifying and others we don't have control of modifying. And so it's like a mix of both sides of the executive branch.
Yeah, and ultimately, sorry, Justin, I'll let you jump in. But I mean, ultimately, and speaking just from my 20 plus years in the procurement office and as an attorney, you know, my goal is to make it fair, right? And if I'm the procurement office and I can find a way to move forward and adjust and resolve the issue at the procurement level and not elevate it to another level or to the courts, that's what I'm going to do. So I think that's another option that's always available.
And that was going to be part of my comment too, Sarah. I mean, ultimately, you know, the arguments were fantastic. The presenters did a great job. I'm not going to comment on Chris, but on all the others. But the notions, and we cite laws and we talk about what the rules say, but there's this underlying concept of equity that filters its way into a lot of protest officials and underlying what's sort of the common sense approach. And I'll give you perspective because Chris was nice enough to reference Minnesota law 16C04. It's really 02. That's almost more controlling in the definition. But in Minnesota, if you went back 5 years ago and this protest came through, you wouldn't have a whole board as you do in Maryland. You'd be stuck with a guy like me who would be looking at it and trying to figure out what's the right outcome, what's a just outcome, what's equitable. And by the way, based on the statute and the definition of organizational conflict of interest in Minnesota, this would have really, the outcome of this would have really been dependent almost on when World Equipment actually spoke to the agency. And did they speak to the agency before they started drafting the solicitation? And if so, it probably would have been okay. But if they talked to them after the agency started drafting the solicitation, it probably would have been considered an organizational conflict of interest, and World Equipment would have been prohibited from responding. So just a little
That's how
background.
Illinois would have seen it. Yeah. Yeah. It's interesting. You know, I could brag and say, you know, I've never been reversed except once and we won on appeal. But the reality is I've always been the court of first review, right? I've always been the place where you had to bring your challenge. But the fact is we changed things more than we didn't. We actually fixed the problem, right? So, you know, there's this, I have this abiding belief that the procurement people having a first shot to fix their own problems is a good thing, right? Because they will, and it keeps the courts from getting busy. Now that might keep them from developing big, long lists of decisions that create complex research topics for people, but it keeps business going and it keeps stuff being built and it keeps people competing in the process because they know if they complain, their complaint is heard and it gets fixed. And, you know, it's an interesting place, right?
So Larry, if I could just, and we're running out of time, but I just want to flag what Mike's saying, because remember, Mike is the reporter on the model procurement code. And what Mike is arguing is that the model, and Mike, I'd welcome to your response to this. I think you're arguing that counterintuitively, there should be an exhaustion requirement at smaller governments. There should be a requirement that you protest first to the procuring office and only then can go to the board or to the court. But there's an exhaustion requirement if it's in a smaller government.
That's what we have in Maryland is you have to go to the procurement officer first. And then what's really interesting, leading to a whole nother sort of can of worms at our level is you're bound by the issues that you brought to the procurement officer. So you can't raise new issues unless you've exhausted your administrative remedy with the procurement officer first. And that always leads to, because cases sort of expand as they go along, how broad was the issue in front of the procurement officer? Is this really the same thing, or did you need to file another protest? And it's a fine line because, again, you want everyone to have the opportunity to be heard and you want fair procurements, but you also want to be able to get a resolution to allow a contract, whether it's that one or the next one behind it or whatever happens, to move forward. And we end up with sort of like we call them sort of elevator protests. We get the first protest, then we get the second protest, then we get the third protest. And, you know, we've had them go 5, 7 protests deep on one contract because in discovery, we find out something new. In the deposition, we find out something new. And it all goes back to what's timely. You know, when did you first know? When should you have known? And it's really difficult. We now try and consolidate everything that's close enough in time together to do it all at one time before moving forward. But sometimes you just can't because you're a week before trial and then a new issue comes up in the last deposition and you don't want to hold the first one up to wait for the other one to catch up to it. So it's difficult, but like I said, we do require that you go to the procurement officer, and if the procurement officer doesn't address the issue, or if the issue wasn't raised to the procurement officer, it can't come to us.
Right. And then there's also the question about what constitutes the record and whether or not you can reconsider findings of fact, right? Which depends on the state you're in. Like in Illinois, it was an administrative appeal. So findings of fact were made at that procurement officer level, right? And unless they were without basis, they were done. You couldn't overrule that finding of fact, right?
Right. We're not, to us, it's whether it's arbitrary, capricious, unreasonable, unlawful. You know, so it's that old, doesn't necessarily have to be the best decision or necessarily the right decision. Was it a reasonable one? Was it arbitrary and capricious? Would I, you know, we're not allowed to second guess and say it would have been better to do it this way. You know, the procurement officer has the firsthand knowledge of what's going on and what's, you know, whatever it is. So we're not supposed to second guess things. But there's sometimes a fine line between second guessing and arbitrary.
Yep, absolutely.
All right, folks, we're running a little over time. I want to thank you. I couldn't think of a nicer way to end the series. I really appreciate your comments, and I really, really appreciate all the work that the advocates put into presenting this evening. It was very, very nicely done. Thank you. Thank you all. Thank you, folks, for joining the series, and look for our summer series next year. Take care.
Thank you.
Thank you.
Bye-bye.